clerk will read out the names. And in the watch. First class.
A very wonderful evening to you. It's always a delight to have you join us here on Parliament and Governance. I'm Uyag Mofwegbe. We're live in Benin City, Nigeria. This week on the program, we're taking our focus altogether to a different issue. We're looking at the Constitution, not just as it is right now, but we want to pay attention to the calls for amendments of the Constitution. But quickly, let's put on record that the Constitution has seen quite a number of amendments. In fact, perhaps the Constitution is one area of our national life that has enjoyed, for want of better words, more of attention than many other issues, because the conviction is the Constitution is the pivot around which every other issue revolves. In fact, we can't talk about the rule of law, for example, if we don't appreciate the place, the pivotal role of the Constitution in our national development. However, there have been controversies regarding the calls for review, or if you like, amendments of the Constitution. As of today, what we have is the 1999 Constitution as amended. You have people across this country who are saying, look, this Constitution as it stands doesn't address the everyday issues that the average Nigerian deals with, especially in light, in 2020, and in light of the realities we have to grapple with day in and day out. However, there are also voices saying, whether we like it or not, all of the reviews, all of the amendments we have seen concerning our Constitution have been nothing but waste of time, waste of money, waste of energy, and waste of all other forms of resources. So the question is, should we leave the Constitution as it is today, or should we go ahead and look at areas that need to be amended as quickly as possible so we can nip all of these nagging problems in the boards? The conversation is ongoing. As it stands today, we understand that the Senate is calling for a memoranda as to say, look, let us know exactly what area of the Constitution you think requires amendment or needs to be reviewed. And we have to know that in the next 2 weeks. Of course, we're counting down already. We just have less than 2 weeks until that time. But what will make the difference in this review that's been proposed as compared to all of the reviews, all of the other amendments that we have seen up until 1999, when the very major and groundbreaking amendment was done to the Nigerian Constitution? I have with me on the program this week a very brilliant lawyer who will help us create context and bring insights into all of these issues on this week's edition of Parliament and Governance. Stay with us. I'm joined by Barrister Matthias Obayiwana. He's a Benin-based legal practitioner. Matthias, it's always a pleasure to have you on the program.
Thank you.
I want us to look at the Constitution. I've known you to be, I don't want to say a fanatic, an enthusiast of the Constitution, because you believe the centrality of our lives as a nation, as a people, is the rule of law. And the rule of law is anchored on the Constitution, the provisions of the Constitution. There are people who believe we should be dealing with what the Constitution provides as of today. But you have those who think there are other areas of the Constitution that are probably obsolete, that do not adequately address the problems that we have as a country. What's your take generally as a lawyer?
Yes, I take the view that the Constitution as it stands is long overdue for an amendment.
Okay.
In order to address, most of the issues, agitations currently, being raked up from different regions. Now we say we have a Federal Republic of Nigeria, and by a federation, the arrangement as it stands today, by the practice and as contained in the Constitution, wherein the center appears to be stronger than the states, that by itself does not portend a federation or a federal republic. Rather, it's more of a unitary system of governance. So we're in a true federation, like America or Canada, federation or confederation. you have the various independence of the states. Every state is truly independent in every aspect, in terms of revenue mobilization, in terms of natural resources, you know, a judiciary, police, security, you know, whatever, they are fully independent. We do not enjoy that kind of status in Nigeria today. So the constitution needs to be amended in order to create room for a true federation, in such a way that the states of the Niger Delta, for example, could be allowed to develop at their own pace, have a use of their resources of petroleum and other natural resources that they have within their region, then donate to the states. Because right now everything goes to the center. By Section 162 of the Constitution, the Mobilization Commission has been set up to ensure, Fiscal Commission has been set up to ensure that monies are taken to the various states to take care of their needs. Whereas it ought to be the reverse. The states will have money for use to run the states and donate to the center, for the center to take care of those federal parastatals, maybe immigration, you know, other federal agencies that in such a way that the center can handle. The various states will donate. But right now, you find the states in the Niger Delta will bring their resources on board, and then by the Fiscal Mobilization Commission, they say, okay, now come and share 30% derivation, whatever that is on board, take 30% back to the Niger Delta from where the greater resources is coming from. And using the Niger Delta as an example, we also have natural resources in the north. Yeah. We have gold, you know, we are in the east, we have coal, and all, you know. If the various states are allowed to progress at their own pace, in such a way that they can tap into their resources, develop it for the best use of the people within their enclave, sent to the center, Nigeria would have been better off than it is today. So in a true federation, the kind of system we are running now, it is not, we are not a federal republic in the real sense, but in the books, we are a federal republic. So there's a need for an amendment of the Constitution to give that true reflection of a federal republic of Nigeria, in that context to the country. So that is one. And within that context of that amendment, we are going to ensure that it should be a need for state police. The security architecture should be rejigged in such a way that every state, because you say the governor is the chief security officer of the state, just like the commander-in-chief of the Federal Republic of Nigeria, of the armed forces is the president. The president can be in charge of the armed force of the army for as far as the police is concerned. If you say the governor is the chief security officer of the state, and the governor cannot give directive to the police in the state that is appeared to be a federal agency, we are like the Federal Republic of Nigeria. We are like the true independence of the state. So in a state like in America, the various in New York, Minnesota, or in California, Los Angeles, they have their own police.
Right, state police.
They have their state police. So whenever it is coming up, the governor of the particular state will be called to action. He can mobilize the police.
He has resources to deploy.
Yes, to deploy. It is when it goes beyond the state, they cannot call on the federal, who cannot send the military to assist. I agree that for the military, that should be a federal affair. For police, I don't see any reason why we cannot have a state police. The argument that is being made, the various states can abuse the privilege, or can abuse their powers if there's a state police. Who says that the federal cannot abuse their powers as a federal police?
The last time we had an amendment in the real sense of the word in this country was in 1999. And that's the constitution we're using up until today. So it's been a little over 2 decades that we had amendments to our constitution. What has happened in between those 2 decades? I mean, have we not been living as a people, for example?
Yes, we are believing. You see, the moves have been there for an amendment of this constitution.
There have been calls.
There have been calls. And as you see, under the regime of President Jonathan, you find out that a national conference was set up and well funded to provide solutions, areas of amendment. And professors, heads from all over Nigeria were put together from the various regions to ensure that to fashion a proper way of how Nigeria will go in terms of restructuring, whatever man want to call it, because you cannot restructure under the present constitution.
Right.
You must amend it to fit into that area you want to have Nigeria restructured, so Nigeria can enjoy that unity that we desire. But again, the various regions will be taken care of, so that no region will be neglected. So in terms of development and all of it. Now a paper was delivered, a report was given from that constitutional conference. Rather than adopt it, as the pivot for the amendment that has been sought after the end of that legislature, everything was swept under the carpet. So for me, if you're talking about constitutional amendment, people bring memorandum and all that to come and suggest to us what we should do. If the National Assembly is really serious about what they want to do, go pick up that paper, the National Conference report.
From 2014?
Yes, go pick it up and look at those issues there. These issues have been addressed. So because the legislature has, the tenure has come down and we have a new tenure of legislation now, do you not say that all the effort of the legislature put into that report of the National Conference, have been swept away? No, that exists. So there are still genuine issues. And I'm sure that issues of the true federation allow the various states to develop at their own pace. I'm sure those kind of issues were addressed at that time. So we should go back. That should be the first start point. I think, Mamanda, you get that one first. Start working with that, and then when they now have a memorandum being brought on board, the guy cannot act up to whatever you want to do. I don't see any reason why we should not have an independent judiciary. In a recent, under the Section 162 of the Constitution, Section 9 about, it is provided herein that yes, whatever resources that is for the credit of the various courts should go to the National Judicial Council. From that National Judicial Council, they cannot, give funds to the various heads of courts, across Nigeria to ensure that the judiciary is being funded. But is that the case today? You see, our judiciary going cap in hand to the executive, asking for funding. You find whereby the judges cannot by themselves ask for their needs because they cannot speak for themselves. It is the bar that can speak for the bench. They can't speak for themselves. Many judges do not have vehicles to move. They don't have housing. They still record with long hands. A lot of issues that have to be looked into. If there is an autonomous judiciary, financially autonomous judiciary, you will not have this kind of system. You're going to have a better judiciary, a more independent judiciary. So we need to have that full autonomy. So if the Constitution, as it is, Section 162, Section 9 is not strong enough to provide for that independence of the judiciary, there should be a need for an amendment to have a clear and unambiguous provision of the Constitution that will make it very clear to ensure that the various heads of court should be given all their needs to function on their own without going cap in hand to the executive.
As it stands today, while a lot of persons are clamoring for a review and amendment of the Constitution, have we been able to enforce the law as it stands right now?
The law as it stands right now, I just give an example of Section 162.
Exactly, that has to do with autonomy for the judiciary.
Exactly. But the will to ensure that this is done, the issues have been brought before the law court and the courts have decided that yes, the judiciary is autonomous and they should be entitled to their financial autonomy. But in the real sense of it, that is not the case.
So is it more of amendment of the law or the ability to have the will?
Yeah, for that, it appears to be not to be more of an amendment of the law, but I believe that if the law, because the argument for and against,
right,
to say, well, if they give autonomy to the judiciary, they on their own cannot give out contract. They have to rely on the executive. They on their own cannot, overlook oversee certain things that is going on. The executive have to come in. There should be more provisions in the Constitution.
Okay.
That will further expand the provision to further empower the judiciary, to let them know what they need to do, how they can do it to ensure that they have an autonomy, a full financial autonomy. It is required. I do not see any reason as we speak today. I'll be clamoring that the provision in Chapter 2 of the Constitution, which is the fundamental objective and the principle of state policy, should be made justiciable. Under Section 6C of the Constitution, it is provided therein that all those beautiful provisions in the fundamental objective and the principle of state policy in Chapter 2 of the Constitution, they are not justiciable. No Nigerian can go to court to ask that it should be provided housing, should be provided job, should be provided food. These are basic things that you find in developed countries.
Right.
When Nigerians even travel abroad, they are put in a refugee camp. The government of a particular country provide for them. They give them money while they are there.
In some cases, insurance cover.
You understand? So, but here as in Nigeria, you find we are even kind of treated more than refugees. Refugees, if you are in other countries. A Nigerian who is able-bodied cannot find job. How many unemployment benefit? How much do you give to them? How many Nigerians have you seen that they give you unemployment benefit because you cannot find job? They are giving you free housing. They are giving you free medicals, whatever it is. No. People still die by the reason of the fact they cannot access the drug on the shelf.
Sometimes for something as basic as malaria or fever.
That. So now, meanwhile, if the fundamental objective of state policy, I make provision for all of this. free and affordable education, free and affordable health care, and the rest of it. They are all provided there in Chapter 2 of the Constitution, housing, feeding, and all of that. Whereas in Chapter 4 of the Constitution, we are provided that we have fundamental right to life, fundamental right to dignity, to freedom from cruel, inhuman, and degrading treatment. If a man cannot find a food to eat, cannot find a place to lay his head, are provided for in Chapter 2 of the Constitution, can such a man be said to enjoy fundamental right to dignity of human person and provided for in Chapter 4 of the Constitution? It's a mirage. It's like giving somebody something by the right hand and taking it by the left. So it's high time that section of the Constitution is amended to ensure that the full enjoyment of fundamental right to dignity of human person is enjoyed if every Nigerian who is able-bodied cannot find a job to do, is looking for a place to lay his head, the government should provide housing for them.
There are two
provide
questions.
Food for them.
There are two questions I need to ask you, but that will be...
So an amendment will be the only panacea
that will fix this problem.
That will fix the problem. If you don't amend the Constitution in that wise, we'll continue, lamenting.
Okay, just so we don't continue lamenting, we're going to take a quick break right now. When we return, there are two questions, very salient questions I must ask Barrister Matthias Obayiwana before we're done with this discussion this week. Stay with us.
I dare to tell this nation today that this is the problem. This constitution can never give us progress. This constitution can never give us peace. This constitution can never give us unity. And unfortunately, most of us in this National Assembly, we don't have the spine to face what we need to give this republic to have peace and progress. What do I mean? This constitution has 68 items. 68 on the exclusive list. This constitution has only 12 on the concurrent list. And those 12 are written so nebulously, so fraudulently, that you know that the intention is to even undermine those concurrent lists.
Thank you for staying with us on the program. I was just going to ask you before we took that break, but it was necessary we did that. What are some of the obstacles on our path to amending the Constitution successfully?
Well, most of the obstacles are bureaucratic. A lot of delay. You talked about the immediate past legislature.
Right.
In fact, if the one under other President Jonathan, you see all the beautiful provision by the National Conference that was brought, and the white paper was not adopted, and then the National Assembly cannot, let me not use the word dilly-dally, because I actually expect to be proactive. I've seen them pass certain bills, they fast track it. They say that this is very, very urgent. They give first reading, second reading before you know it is passed. The kind of urgency they give to such bills that have been passed in the past, for which maybe the executive were interested. They should also look at that to ensure that this kind of bill that the Nigerians are also interested. I know there are certain provisions that sometimes the two houses of National Assembly must pass. The House of Assembly, House of Reps, and House of Senate. They must pass it, and they must send it to the various states for the state to also sit, and they also pass it. You must get 2/3 of the various states before you return it back to the House to be passed. All of this could take a while. But if Nigeria has the will, political will, to ensure that this thing is driven, to brought into being, I don't see any reason why they cannot drive this process, with the speed that is required. Look at electoral reform. Because if you talk about amendment, there are several areas. Electoral reform, even the issue of political parties. INEC be given power to prescribe political parties, to deregister political parties. Meanwhile, under the Constitution, you have the power, the right to associate under Section 40 of the Constitution, fundamental rights. Okay. Now you have been given power to associate and as a political party, INEC have been given powers to deregister them.
Is that contradictory? Is it contradictory?
It is contradictory. So why would INEC be empowered to register a political party and deny many people the right to assemble under a political party?
And pursue a common goal.
Exactly. By reason of the fact that maybe you could win an election and the rest of it.
Or you don't have a national spread.
Exactly. The political parties exist only for the purpose of winning an election. It can exist as a pressure group. It can exist as a, as a means of, reaching out, even going to promoting a particular cause.
Maybe pursuing an ideology.
An ideology. So if that is the reason for setting up a political party, the fact that they didn't win an election, should that be a reason to say you want to remove their registration? So, and these are powers given to INEC under the Constitution. There's a need for an amendment to ensure that political parties enjoy their full rights, fundamental right to association. That is one. We're talking about an amendment on the issue of the INEC conducting election, issue of transparency in the electoral process. You find that the beautiful provision that was made in the legislature before now as to the online transmission of results. Go find whereby results are being transmitted, collated from a particular unit before you get to the collation center or to where it finally will be read out. Different figures from what you have. If there is an electronic transmission of results, we have all seen it here. You transmit it, and we follow it through to the collation center. At the end of the day, the issue of electoral malpractices would have been reduced. All those were codified, in a bill that was sent to Mr. President at that time, which they didn't pass. Now, they didn't pass it. The legislation could not muster the courage to veto the president. So that kind of bill ought to be reintroduced by the House, by this new legislation. Whether or not anybody proposes it, any of them can pick that bill and reintroduce it, and then fast track the process to ensure that it's passed. So the idea of pay leave services to it, to say, okay, we want to amend the constitution, we want to do this, everybody submits memorandum, without submitting, you don't start sorting it through. Bureaucracy come into play. Before you know it, they say, okay, this is the end of this legislature, we are sorry, we cannot do anything, everything goes to the dustbin. The next one comes and starts afresh the same issue. So if they have the political will to bring this into pass, it can be fast-tracked. Everybody can be, like fundamental right, provision in the constitution, the rules to enforce fundamental right it's being stated that it should be given the urgency that it requires. That's what the CJN provided, the rules that the CJN made, portion for the constitution. That anything that will do fundamental right of a citizen, the court must give utmost urgency to it. And you can see that most courts, when they receive fundamental right action, they fast track the process to ensure that the thing is done quickly. That's why I'm calling upon the legislature to be up and doing. They are really serious about this. Don't pay lip service to it. If you're really serious about this amendment, whether or not you receive memorandum from anyone, go pick up the National Conference reports.
Okay. Is that sufficient?
It's sufficient. It's sufficient because they have addressed all those issues there. It's a beautiful document. They have addressed all those issues there. It's sufficient. The issue of a true federation,
resource control.
Resource control. They are contained. They are all be dealt with there. So go pick that document up, look through it, and propose an amendment. That is not to say that Nigerians should not send memoranda.
Of course.
We will send a memorandum to them, but they should be up and do. They should not give us an excuse. Oh, I did not receive the memorandum early enough. That is why we failed to get this thing done. If you are going to read it in both houses, they should give it emergency reading. First reading, second reading, pass it. The other person you read and pass. Then you move it to the various states, let them all pass, let it return back. So that at the end, before the end of the legislature, this exercise would have been complete, and there will be a true amendment. Not that 5 minutes to the end. Oh, we are sorry, there's nothing we can do now, and bye-bye, then we will come back again. The petroleum bill suffered the same.
The PIB.
The same fate. The amendment of the electoral bill, that empowers INEC to have an electronic transmission of results. So far, the same fate. Even though they succeeded in passing that one, but in completing that process, but the president refused to give assent, and they could not veto it. That issue is still on the front burner. So why can't they not go back instead of starting afresh every now and then? Pick the documents where all your colleagues have stopped. Continue from there. Look at those issues. Let the both houses, if they are convinced, pass it and represent it to the president for assent. So that's what I expect them to do. So they on their own need to convince Nigerians that this exercise is not under charade.
That is worth the while.
That is worth the while. You must convince us. Not that at the end of the day, after all the money that they put in, and then you say, oh, well, we couldn't complete the process. Sorry about that. Next legislation will take it.
From what I can say right now, off the top of my head, I'm very convinced that going forward, this is a conversation we will continue to have until such a time when we have a constitution that truly provides for many of these nagging and nasty issues that we confront or that we're confronted with in Nigeria today. Thank you so much, Barrister Abatai Sobayawana, for sharing these brilliant and incisive insights with us on the program this week. That's Parliament and Governance for you for this week. I'm Uyag Mofwegwe. Thank you for watching. Our coverage here on ITV continues. Enjoy the rest of your evening.
Fragment.